What to do if you receive a 3-day notice. If you're watching this, you've likely just received a 3-day notice to pay rent or quit. I know that heart-sinking feeling the moment you see that paper on your door. It feels like an immediate eviction, but I want you to take a deep breath. First and foremost, a 3-day notice is not an eviction. It is a formal request for rent. It is the start of a process, not the end of your time in your home. You have rights, you have time to act, and you still have options. In this video, we are going to break down exactly what this notice means, what the timeline looks like, and the practical steps you can take today to protect your housing. Before we dive in, a quick but important disclaimer. I'm not an attorney. This video is for informational purposes only and is designed to help you understand the California system. Laws can change and every situation is unique. Please use the resources I'll provide later to connect with local legal aid or your county's housing office to get advice specific to your case. In California, a landlord generally cannot start an eviction lawsuit until they have provided proper notice. A 3-day notice is the most common tool for non-payment of rent. It tells you one of two things: pay the rent you owe or move out. That's the quit part within 3 days. There are 3 main types you might see. 3-day notice to pay rent or quit. This is for unpaid rent. 3-day notice to perform covenant or quit. This is for lease violations that can be fixed, like an unauthorized pet or a noise issue. 3-day notice to quit. This is for serious, non-curable violations, like illegal activity on the premises. If you received a notice to pay rent, check the math. It must accurately state the amount of rent owed. It cannot include late fees, utility penalties, or interest. Only the base rent. If the notice asks for more than the actual rent due, it may be considered invalid. One more thing to check. A 2025 California Court of Appeal ruling established that a notice must clearly state the date it was served and when your 3-day period begins and ends. If your notice is missing that information, it may also be invalid. Write that down and bring it up when you call legal aid. It could be a strong defense in your case. The timeline. This is the most critical part. The 3 days are not just any 3 days. In California, these days do not count Saturdays, Sundays, or judicial holidays. Also important, you do not count the day you actually received the notice. The clock starts the day after. So if the notice was posted on your door on a Monday, day 1 is Tuesday. This matters because miscounting by even 1 day can affect your decision, so count carefully. If you don't pay or move by the end of those 3 days, the landlord can file an unlawful detainer lawsuit. This is the actual eviction process. They cannot change your locks, remove your belongings, or shut off your utilities to force you out. These tactics are called self-help evictions, and they are illegal in California, no matter what the notice says or how much rent is owed. If your landlord does any of these things, call 911 to document it and contact legal aid immediately. You may be entitled to damages. After they file the lawsuit, you'll be served with court papers. You have 10 court days, that's court days, not calendar days, to file an answer with the court. This is a change that went into effect in 2025. So you may see older information online that still says 5 days. Do not rely on that. If you don't respond, the landlord can win by default. If you do respond, the case goes to court. A sheriff's lockout only happens at the very end, after a judge has ruled in the landlord's favor and a court order is issued. One more thing worth knowing. California's Tenant Protection Act may apply to your situation. If you've lived in your home for 12 months or more, your landlord may be required to have just cause, a legally valid reason, to evict you. Not every rental is covered, but many are. Visit the California Court's self-help website at courts.ca.gov to find out if your unit qualifies. If it does, you have additional protection beyond what we've covered here. Don't panic, but do be proactive. Here is an action plan. Step 1, verify the notice. Does it have your name, the correct address, the exact rent owed, and the landlord's contact information, including a name, phone number, and address where you can actually send payment? California law requires the notice to tell you exactly how and where to pay. If that information is missing, the notice may be defective. Write it down. Step 2, contact your landlord. If you have the rent, offer it. If you don't, reach out before the 3 days are up. You might be able to work out a payment plan. Get any agreement in writing. Step 3, seek rental assistance. Many counties have emergency funds. I've linked resources in the description. Step 4, call legal aid. Search for legal aid in your county. Most California counties have free services for tenants facing eviction. Step 5, document everything. Keep a copy of the notice. Take photos of your unit if there are repair issues you've been withholding rent for, and write down every conversation you've had with your landlord. Rental assistance options. If money is the main issue, look into these sources. Dial 211 from your phone anywhere in California. They are a treasure trove of information and can direct you to local nonprofits offering one-time emergency rental assistance. County programs. Check your specific county's Department of Consumer and Business Affairs or Housing Authority website. Programs are often refreshed quarterly in 2026. Mediation. Some cities offer free landlord-tenant mediation. This can sometimes help both sides reach an agreement without ever setting foot in a courtroom. Mistakes to avoid. Avoid these common traps. Don't ignore the notice. Ignoring it won't make it go away. It just makes it harder to defend yourself later. Don't move out too fast. If you move out before a court order, you may have no legal leverage to negotiate the debt. Don't pay partial rent without a deal. If you give your landlord money without a written agreement, they might still proceed with the eviction using the remaining balance. Always get an agreement in writing that says, if I pay X, this notice is void. Let's recap everything. A 3-day notice is a warning, not an eviction order. The notice itself may be valid. It needs the correct rent amount with no added fees. Your landlord's payment information and the date it was served with the start and end of your 3-day window clearly stated. The notice itself must be valid. It needs the correct rent amount with no added fees, your landlord's payment information, and the date it was served with the start and end of your 3-day window clearly stated. Your 3 days do not count weekends or judicial holidays, and day 1 is the day after you receive it. If the landlord files an unlawful detainer lawsuit, you now have 10 court days, not 5, to file your answer. That changed in 2025, so spread the word. Your landlord cannot lock you out, remove your belongings, or shut off your utilities at any point in this process. That is always illegal. Check whether the California Tenant Protection Act covers your unit. If it does, you have additional just cause protections. And no matter where you are in this process, you are not alone. There is a full network of legal aid organizations, county programs, and mediation services available to California tenants. Check the links in the description for legal aid directories and rental assistance programs in your area. If you found this information helpful, please subscribe to Benefit Breakdown. And if you like this video, please like it and share it with a friend. We're here to help you navigate your rights and resources as Californians. Stay strong and keep taking those next steps. Thanks for watching.